G'day friends and foes, how are you all doing today? It's Arjay here with TINLA episode 24, or Arjay's This Is Not Legal Advice, and nor is it. So, what do you think of my new haircut with my emoji and my moustache? Anyway, I did a video last night which was TINLA episode 23, which I called How to Do an Authorised Protest in Queensland and Elsewhere and Why It Is a Good Idea. So I am particularising these videos for each state and territory, especially with the massive, hopefully, protest coming on the 30th of May for every state and territory capital, as in the mainland territories combining Jervis Bay with Canberra. So, in other words, in Canberra, Darwin for the two territories, Brisbane, Sydney, Melbourne, Hobart, Adelaide and Perth. And there's also a little trial run for an authorised protest in Queensland at Brisbane for the 24th, which is coming up. But anyway, so in this video, I couldn't get a red background, but pink is the closest I could get for the Western Australian version. So let us begin. This camera's a bit wobbly, but anyway. So as per the perth.wa.gov.au website, under the heading Marches and Rallies in the City, basically it says that an activity approval team exists, and you can call them on 0894613333 to confirm available dates and booking options. So I can do that after this video. And anyway, where a group of 3 or more people assemble with the intent of holding a public meeting, rally or march, the organisers will be required to submit an application to the city to carry out such activities. So that's to Perth City. Along with city support, you will need to seek West Australian police approval in accordance with Section 7 of the Public Order in Streets Act 1984, Western Australia. The public meeting and or procession form can be downloaded, and you can also just find it in the regulations as well. And then that gets lodged at the local police station. And also you inform the city, of course. So going through the legislation now, we have the Public Order in Streets Act 1984, and that has 11 sections. Just go through any relevant ones. So the proper name for the Act is an Act to regulate the holding of public meetings and processions in streets, to provide for the maintenance of order in streets and for related purposes. So it's a long title, and you've got the short title, and an interpretation or dictionary section for section 3. Also includes defining a thoroughfare as including any bridge, tunnel, underpass, arcade, pavement, footpath, court, passage or other place to or through which access to or from a street is permitted to the public. So section 4, public meetings and processions, subject to any direction given by a member of the police force under section 9A and the provisions of subsection 2, where the holding of a public meeting or the conduct of a procession substantially conforms with the terms of the permit relating to it, a person participating in that public meeting or procession who observes such conditions and limitations as may be specified in a permit may position himself in or proceed over any street referred to in a permit and is not by reason of anything done or omitted to be done by himself for the purpose only of his participation in that public meeting or procession, guilty of an offence against the provision of any other act or law regulating the movement of traffic or pedestrians or relating to the obstruction of a street. So basically, as I said in the Queensland Authorised Protest video, that if you do an authorised protest, it has certain benefits, including indemnity against certain civil and criminal proceedings. So, it's beneficial to have an authorised protest that way, as well as the police feel respected. So, provide respect in return, that people haven't done a so-called unauthorised protest. And again, people can argue that the whole thing's unconstitutional, and that's fine, but this is just so people can get out there and start protesting now and hopefully not have to worry about getting fines, etc., or getting arrested. So subsection 2 goes on about there's deemed conditions, including that people don't obstruct the free passage of any ambulance, fire brigade vehicle or police vehicle, and where any person contravenes that condition, the holding of the public meeting or the conduct of the procession shall be taken not to have conformed with the permit. So if you have some kind of jerky people trying to get everyone in trouble, agents provocateur, or people that are trying to discredit the movement, or even people just being jerk-offs, then they can be liable themselves, and just tell the police what you observe and let them deal with it, is a suggestion. In subsection 3, for the purposes of this Act, an assembly shall not be taken to be a public meeting unless it comprises 3 or more persons, it is for the purpose of communicating or expressing any view to or of ascertaining the view of the public or any section of the public, whether or not an organisation or body of persons having requirements for membership, or of demonstrating as to any matter, and members of the public in general are invited, induced or permitted to attend. Or B, if the assembly is convened solely for the purpose of divine worship. So that has a couple of interesting points. So if someone has a demonstration and they are not inviting or inducing or permitting the general public to attend, then it's not a public assembly. So, these requirements for getting permission to or approval or the non-objection to this public assembly, it is a little bit different in Queensland, the wording of things, but if you don't invite the public in general, then it's not deemed a public meeting, and this Act doesn't apply to them. See, my little emoji character looks sad for some reason. I'm not frowning, but it seems to be doing that a lot. Anyway, so then it goes on about a procession, so that comprises of 3 or more people, and the people are assembled with the intent of moving or move from the place of assembly by means of any street as or substantially as a body of persons in orderly succession proceeding by a common route. So again, another interesting point is it's not a procession, therefore under that definition, if just say you have a start point and an end point and people move their own way there. If someone goes down X street versus Y street and then someone else takes a shortcut or whatever, then that's not a procession. A little emoji just poked his tongue out. I didn't do that. So section 5 is notice of assembly. A person who, or body which proposes to hold a public meeting in a street, conduct a procession, not being a funeral procession, in or which is to proceed through any street or does both, then they may, and may is very important, give written notice to the Commissioner setting out the proposal and applying for the grant of a permit under this Act in respect of that proposed public meeting or procession, or if the proposal is both to hold such a public meeting and conduct such a procession in respect of both the proposed meeting and the procession. So if you do Google searches on how to hold a protest in Western Australia, including, potentially government websites as well, it incorrectly states that you must receive permission, where the Act itself clearly states may give written notice. So that is a big deal if someone was to be fined and challenged the Act or the fine based on the Act, saying, hey, look, if I got fined for not seeking approval for this procession or march or whatever you want to call it, protest, rally, then, the Act says you may do it. That means that you don't have to do it by definition. Then subsection 2 goes on with the details, so it's got the same as basically what was in Queensland, and it's probably going to be the same in every state and territory. So the date, time, when things will kick off, when they will be finished, the boundaries of the area to be occupied by the public meeting, the route of a procession to be followed, the details of the person making the notice, name, address, that kind of thing, the purpose of the meeting or procession, an estimate of the number of people who will participate, and again it's an estimate, so who really knows if 50 people are going to turn up or 5,000, as an example. Particulars of any other matters as may be prescribed, and the notice shall be given not less than 4 days before the date of which a proposed public meeting or procession, or within such short a period as may be agreed by the Commissioner, as in the Police Commissioner, or an authorised officer, and may be required to be verified in a manner acceptable to the Commissioner or an authorised officer. And on receipt of the notice, the Commissioner or an authorised officer shall act expeditiously, or expeditiously I should say, to determine the application. So, they can't sit on their hands and just let the date go by. Section 6 deals with authorised officers. Skipping ahead. Section 7, permits. The Commissioner or the authorised officer shall have regard to the information furnished in the notice and any other information available to him, doesn't say or to her, in relation to the proposed public meeting or procession, and may, by a document furnished to the person or body giving that notice, grant permission, or, they can also grant permission with conditions, or they can refuse the permission. The Commissioner or an authorised officer shall not refuse to grant a permit for a public meeting or procession in respect of which notice has been given, unless he has reasonable ground for apprehending, so believing in other words, that the proposed public meeting or procession may, and it's got 4 little points, so occasion serious public disorder or damage to public or private property, create a public nuisance, give rise in any street to an obstruction that is too great or too prolonged in the circumstances, or places safety of any person in jeopardy. So if they reject it based on any other ground, then that's an invalid ground, and they must consider, or they must grant it unless these grounds are met. And Section 8 is about reviews, so you can get it reviewed instead of in Queensland by a magistrate's court, you can get it reviewed by a state tribunal. The Western Australia legislation is a bit more flexible or better in that you can get a review of any condition or limitation specified in a permit granted in relation to the proposed meeting or procession, because basically in Queensland it doesn't have that part, and there are ways around things, but that's another story. Section 9 is about offences and evidentiary provisions. So basically you can't obstruct ambulance, fire brigade, police vehicles, etc., or incite others to do so. You can get a $200 fine, which is interesting that it is such a low fine. Often in legislation now they just say so many penalty units and have regulations to change what one penalty unit equals. So it might equal, say, $133 in your state, it might equal $100, $98, whatever, but often they will say 10 penalty units as an example, which might well be $1,300 as an example. Because over time with inflation, $200 back in 1984, if that's what the penalty was back then, was a lot more money than $200 is worth today. So subsection 2 is a bit dodgy in a way. So it says, where in any proceedings for an offence against subsection 1, that's section 9, subsection 1, it is alleged in the charge that A permit has been granted under this Act to a person or body named therein, or B, a public meeting was held or a procession was conducted pursuant to a permit, it shall not be necessary for the prosecutor to prove the facts so alleged in absence of evidence to the contrary. So why I say that's dodgy is basically so if someone is accused of having a permit for a public assembly, i.e. an authorised one, and say some people block an ambulance as an example, then someone could be charged who wasn't actually one of those blocking an ambulance, but this legislation purports to say that that person could be charged and fined if they can't prove that they weren't one of those people, which is, as I said, a bit dodgy, putting it nicely. Really, it's a criminal act and should be beyond reasonable doubt instead of, it's not even just strict liability, it's saying that you're guilty unless you can prove otherwise. Section 9A is about maintaining order in the streets. So the police can regulate traffic, whether pedestrian, vehicular, or of any other kind in the streets, prevent or remove obstructions, such as, you might have, like one of those road barriers, like a fluoro yellow and black thing in the road, so the police can move it so people can walk past, that kind of thing. And maintaining order in the streets. And anyone who, knowing of the existence of a direction given under subsection 3, which is reasonable directions to a person for the purpose of giving effect to an instruction, does not comply, then they can get a $2,000 maximum penalty, and that was inserted in 2004. So section 10 is about protection from liability, which indemnifies someone for doing certain actions, even if it turned out to be wrong, so long as it wasn't done maliciously and without reasonable and probable cause. So that is a double-edged sword, because that can protect, the protesters as well, but it can also, say, protect an officer if the officer, buggers up, basically, makes unlawful orders. As long as it can't be proved that they were malicious or didn't have any reasonable and probable cause, then they can't be liable for that. So that might include, false arrest, that kind of thing. And Section 11 is basically that regulations can be made, and Section 12 has been deleted. Don't know what it was, maybe I might look that up later. But deleted in 2004. So then we go to the regulations, which is Public Meetings and Processions Regulations 1984. That is only 3 sections long. You have a citation, or a short title, in other words, commencement, and forms, saying that within the schedule there are forms for specific purposes. So subsection 2 says, the forms prescribed by these regulations are for guidance only, and nothing in these regulations requires the use for any purpose of a prescribed form, nor requires any application or notification to be in writing. So that's another interesting point, again, to do, like, arguing it in a novel way, is about, are authorised protests even required in Western Australia, if they were to even include invitations to the general public to join in. But anyway, so Schedule 1 has, or the schedule has Form 1, notice for applying for a permit to hold a public meeting and or conduct a procession. Please give as much detail as is reasonably practicable. So again, covers what time the thing will start and stop, what date, what route it will follow if it's a procession, what boundaries they're going to have for the people, the purpose of the meeting, an estimate for the number of people that might participate, again, estimate only, particulars of other matters, so this form doesn't go into as much detail as the Queensland one, where you're supposed to say about, if you've got a megaphone or whatever. Form 2 is permit to hold a public meeting and or conduct a procession. So what the other one was entitled to. So the first one relates to Section 5, and then this one relates to Section 7 of the Authorising Act. So is there any difference? Seems a bit redundant to have the 2 different sections. And there were forms 3 to 7 that were deleted in 2004. So that's interesting. Next, I'll quickly touch on move-on orders. So they used to be within Section 50, apparently, of the Police Act 1892, Western Australia, but it was deleted in 2006 and basically just moved to a different act, it appears. So just trying to skip through some other stuff that I have left open to do later research, more in-depth stuff. One other thing to mention is with the COVID-19 lockdowns and restrictions, there would be a form on, probably the Ministry of Health's website, Department of Health, something like that, that exempts people from the COVID restrictions, such as, apparently in Western Australia it's moved to 20 people outside, but you can apply for exemptions for that. Now I'll try and find the form. I've been unable to find the correct form at the moment in quickly looking up, but I just thought to add that. So Now I'm going to the Criminal Investigation Act of 2006, which includes about move-on directions. So within section 27 of that, and remember this is a Western Australia video for Western Australia, and most of the states are pretty similar, probably 90% similar, maybe more, maybe less, depending on which way you want to look at it. But basically, every state and territory will have these similar things, move on orders, some kind of form to fill out and provide to the police and the local council as to informing them of processions or meetings, rallies, that kind of thing. But it might be very slightly different in each state and territory. Anyway, so within Part 4, you've got miscellaneous official powers and duties. Section 27, suspects and others may be ordered to move on. A police officer may order a person who is in a public place or in a vehicle used for public transport to leave it or part of it specified by the officer if the officer reasonably suspects that the person A is doing an act that involves the use of violence against a person, or that will cause a person to use violence against another person, or 3, that will cause a person to fear violence, or fear violence will be used by a person against another person, or B is just about to do an act that is likely to, and then basically repeats what I just said above, but that's to prevent it from happening, or C commits any other breach of the peace, or D is hindering, obstructing or preventing any lawful activity that is being or is about to be carried out by another person. Again, another important part of having an authorised protest for Western Australia in this case. If, just say there's counter-protesters, ones that are protesting that we should all be locked up forever, as an example, if it's about the lockdown, then, you can get those people moved on. And the police should do that. Although, sometimes police don't do that, which they should do. And anyway, other grounds are intends to commit an offence or has just committed or is committing an offence, then the police may give an order to move on, paraphrased. That can include telling the person that they can't return for a set period of time, maximum of 24 hours. And the police are to, or must take into account, the likely effect of the order on the person, including but not limited to things like where the person lives, shops, works, transport, availability, health, education, or other essential services. So some of you may remember, as an example, Tommy Robinson in the UK, who was moved on from just having a meal in a restaurant with his family, and then the police basically were stalking or moving him on, following him behind with a massive police, and his little daughter nearly got run over because she got so scared and she was crying, and Tommy was turning around saying, hey, this is my recollection of it. So he was turning around saying, like, hey, stop following us or something like that, because they were already moved on. They were moving away, and then his little girl nearly got chased into traffic or ran into traffic from the stress of it. Hopefully nothing like that happens again to anyone. It was wrong then and it's wrong now, but basically they have to take into consideration things including, the health of the person. You can't tell someone they have to walk away from where their car is and, walk 20 k's away and then wait a day before they can return to their car, as an example, when they live, down the road, or maybe they live far away and need their car, is another example. So anyway, I will attach a video of some people being arrested in Western Australia at a protest or rally, it appears. That was a couple of weeks ago on Mother's Day, and there was a lady arrested for exercising her rights to political communication, I would suggest. And also her son was arrested, who was there for Mother's Day, and apparently 2 other people arrested. There was another person handcuffed but later released without officially being arrested, even though technically if you are detained by the police, even mentally, then that is an arrest. But anyway, so I'll include those videos at the end. They're from Christy Miles. She's a really cool lady, and you can go on her Facebook page and subscribe or follow it or whatever if you like. She does have some really cool content, so I will include those videos at the end, and it'll be interesting to see what she was actually charged with when I find that out eventually, and what can be done about that. But I suggest that the arrest may well have been unlawful, and she may well have been falsely imprisoned along with her son, and it's clear in the video that it's a son because she mentions it, or mentioned it in the written details that went along with one of the videos. But she also did a follow-up video that if it's not too long, I can include it in the end of this video, or just refer you to her page to watch it there, or maybe I do like little highlight clips, something like that, and then you can go and watch the full things on Christy's page on her video. But anyway, please like, share, subscribe, and basically we need to get this message out, because that way people do have less problems with the police, because they may well do authorised protests, whereas they weren't doing it beforehand. So that is very important, I think, to encourage people to get out and protect their rights, that they can hopefully do so in an authorised protest, and therefore be not arrested, not put up with jerky people trying to get them in trouble. If there is a jerky person in your protest, as I said, just go tell a police officer, and the police officer can use their discretion to move that person on for disturbing or disrupting a peaceful authorised protest, as an example, or arrest them if they're threatening people, that kind of thing. Also, there is another issue with the COVID-19 purported health directions, which I argue are invalid anyway, but that's up to other people to make submissions on. I am trying to raise funds to get around Australia, so I have legal standing on a little holiday to every region of Australia that has internal closed borders and these health directions. Then I can get legal standing to challenge these things in a high court, or try and do it in a high court, and it'll probably be sent down to, or possibly sent down to, the federal court to exercise constitutional jurisdiction in a federal manner. But anyway, so please consider not only sharing a video to get the message out there to protect people, and that includes sending it to police officers so they're aware of the law, but also in the hopes of ending this lockdown, please consider donating some money to me. The personal link is at paypal.me/Arjay Martin. I do wish to purchase like a little camper van thing and go around Australia, as I said, which will also, fortunately, as a byproduct, if you want to call it that, give me legal standing to challenge these invalid, unlawful, unconstitutional, state-based health directions, as well as some other, purported legislation in relation to that, and purported directions such as border closures, quarantine periods for internal state quarantines, if that makes sense. So sure, you can quarantine a ship coming in, especially if it has sick people on board, but you cannot quarantine someone just crossing the border who's not sick. I would suggest under various aspects of the Constitution, sections 117, for instance, against interstate discrimination, and section 92 as another example about, you can't have internal border restrictions. There's also supporting High Court cases to back that up, such as Cole and Whitfield, 1984, which was the first case to use the so-called annotated constitution or constitutional commentaries by Quick and Garron, and that was called the crayfish case or the lobster case, Tasmanian lobster case. And anyway, so I personally believe that it is worth pursuing in the courts and that it can be won, and that's what I'm intending on doing, but all of these things cost money. So again, I don't really like asking for donations, but it's basically required because I don't have the financial resources after being a law student for a number of years to go out and do things by myself, and nor should I really. It's to help everyone, so everyone should contribute. So thanks again, and please watch the attached videos. And if you're interested in running a protest for Reset Parliament, including against the lockdown, against things like compulsory medication, the compulsory use of technology, things like microchipping and whatnot as well. I do have some event pages for every state and territory for the 30th of May, and if you would be able to help conduct such a protest, then please message me on Facebook at Arjay Martin's for Australians page. So that's ARJAY MARTIN apostrophe S FLR, and then Australians AUSTRALIANS. So please also find my YouTube channel, which is youtube.com/C/Arjay Martin, and subscribe to that as well. And enjoy your day. Have a great day. I'll have to do more of these videos now. Fun research beforehand. Anyway, cheerio. Have a lovely day. Bye. And I just thought to add, in case, I'm sure most people probably don't know what legal standing is, but basically it's a filter used by the courts to get rid of problematic cases, if you want to call it that way. That's how I explain it. So basically, unless you're affected more so than the general population by a certain thing, then often the courts will just dismiss the case or not allow a case to proceed. So, for instance, if I live in Queensland and I'm a student at the moment, but assuming that I also worked in Queensland as an example, then I could challenge the laws in Queensland or the purported laws in directions and things like Biosecurity Act at a federal level, but I can't go and challenge Western Australia's public health directions as an example, unless I happen to travel through Western Australia, and Western Australia is further divided into regions. So, I would have to travel to all of those regions and then travel to Western Australia, Northern Territory, the ACT, New South Wales, Victoria, and Tasmania, basically, because then I am affected more so than other people for, you know, my trip around Australia, which, as I said, has a secondary feature of giving legal standing to challenge these invalid laws in the High Court. So, you know, there's certain aspects of the Biosecurity Act that are invalid. I'm sure that there'll be certain people, you know, trying to work out what they are after getting this information. I do know that at least one former High Court judge watches my TINLA videos, who I spoke to in person, but, you know, I'm sure other ones do as well. So I might not have many views, but a lot of the time people viewing my videos are so-called important people within a legal fraternity. So anyway, I just thought I'd quickly explain that. So here's the videos from Christy. Cheerio.
You're all sick. You're so sick in your heads.
Well, can you ask them because they won't answer me. Once he's finished speaking, ask him for it. That's your mum.
That is our mum. Yeah. She does. They don't have a reason to arrest her. There's freedom of speech.
Any handcuffs on her at the moment?
Well, that's what they said. She's arrested, but for what?
2, 3, 4, 5, 6, 7 police. 7 police not arresting a lady.
We're trying to be civil.
Social gathering rules, so I suggest you leave.
So are you guys, sorry, but you guys are all standing together as well.
No, you're in a group of more than 20, so you need to understand what you're saying is right and wrong.
Yeah, I've got her on live at the moment.
So it's not lawful because it's an act. Yeah, it's not legal acting.
This is why I didn't want to come.
That's not a law.
This is why I didn't want to come.
I've been told that my mum's under arrest for an unlawful situation. Detained her for what?
Do you understand what?
No, I don't.
Did you hear what he said?
No, I didn't.
Okay, so he just says he's asked for her details and she's refused to provide them.
Not required by law to provide details.
Okay, you're in a gathering, okay? Do you understand what's going on at the moment?
But why is it
I'm in a public
I'm speaking
space.
to one person at a time, sir. Just give me
I'm in a public space with other people of the public.
Yeah.
We are not required by law to provide any details to anyone.
No, you're in a gathering of more than so many people, right? Do you understand that? Do you understand? I'll ask it simply.
So you should be
If you
arresting
wanna
everyone then.
Assume that it's a gathering of a certain amount of people.
Okay, so why are you here then?
I'm here because it's Mother's Day.
At this place?
Yeah, we were all
Not
social
a public
distanced.
place.
But what are you doing here then?
Social distanced and talking.
We all live in the same
We
house.
live in the same house.
Just asking a question. I don't know. Your name? That's why I'm asking the question.
Right.
I'm not trying to be hostile towards you. I'm just trying to ask.
Well, it seems like a very hostile situation right now. It wasn't hostile 5 minutes ago, and now it is.
we were
I
just
wasn't here 5 minutes ago.
we were just walking
I'm
away.
on my bike. I'm over here because Mum's been brought over here. I'm trying to have a
Yeah, but it's like
conversation with you.
they seeked out her out of the whole college.
Yeah, I want to know why she was kicked out. Yeah, no worries. Oh, you go.
And now someone else is being arrested. This is freedom of speech. Dad, we should go and call Wayne Blue before they start talking us.
Hello everybody, I'm actually online tonight at 6:44 Perth time, which obviously is a little bit later for over east, but I just thought that I would reconnect with everybody. Today's been quite busy in the fact that every man and his dog has either added onto the page or wanted to say hello and check in to see how we're going, which is really nice of everyone, thank you. I just wanted to come online tonight. Really, my brain's going, you don't need to say anything. But then I also wanted to just connect with everyone as well, simply because yesterday was a bit of a head spin. It's left me today with a lot of PTSD symptoms. When I talk to people about what happened, I didn't realise that it affected me as much as it did. And I actually end up shaking and tearing and all the rest of it, which is to be expected, I guess, while you're being brave for everybody else and showing them how to actually go about this, or how to fight this unlawful system. And I don't know everything. I rely on a lot of people. Hi, Scotty Barr. Scotty's one of the guys I rely on a lot. I rely on Wayne. I rely on Jim Greer and a few of the others. AJ Martin, which was our senator for Queensland for the GAP non-political party, and quite a few other people. But I guess if you're happy to get on a live, I'm not saying that I was overly pleased with how I looked yesterday as a female, but you know, we've got to bypass those things to actually get people to, hold on, adding you on things to actually get the word out and get people sort of talking about this, get people sharing this video live, get people who know what they're doing to actually be willing to talk to other people.